I'm not actually that surprised that Ryan Reynolds was not deposed because Lively would have had to list all of the people that she deemed had the best information about her emotional distress. And if she did not list Ryan Reynolds as the person that has the most relevant information about her emotional distress, then she is bound by the testimony of the other people that she has listed as having the information or evidence of her emotional distress. Now, many people are talking about how Ryan Reynolds was intimately involved in some of the allegations that come up in this lawsuit. For example, his involvement in writing the script and his involvement in some of the meetings and his experience in some of the actions or items that come up throughout this lawsuit. So why wasn't he questioned about it? Because if he was to be put up as a witness by Lively to support even those allegations, then he would be questioned about his experience as the husband of someone suffering from emotional distress. So it's a big risk for Lively's legal team to put Ryan Reynolds up as a deponent, as a witness to even just her emotional distress, because they cannot limit the questions that the Wayfarer parties could ask of Ryan Reynolds. So if they were to put him up as a witness to all of the things that Lively is claiming, then they have to be willing to have him answer to all of the questions that the Wayfarer parties could come up with. And because there is a lot out there in the public sphere that they could ask him about that has very little to do with this particular case, but could show different holes in his statements and poke holes in his testimony otherwise, it's a huge risk for Lively's legal team to place him as a witness. So just to clarify, the people who are deposed are witnesses that have been listed by the parties. So at the outset of the case and amended throughout discovery, the parties each disclose to the other side who the witnesses are that would be able to provide testimony to support their claims or defenses. So Ryan Reynolds at some point was taken off the list by Lively's attorneys as someone that can speak to her claims. So it's not that Wayfarer chose not to depose him because they didn't want to or they forgot. It's that he was no longer listed as someone that would provide evidence in support of Lively's claims. So there was no need for Wayfarer to depose him because Lively would not be relying on Reynolds' testimony to support her claims. One of the questions that often comes up then is, can he then come to trial? Can he then be a witness at the trial? And if he was not deposed, if the opportunity was not provided to the Wayfarer parties to depose him, to discover what he has to provide, then it is not likely that he would be able to testify at trial. Meaning that if Lively were to try to place Ryan Reynolds on the witness stand, not having allowed his deposition or not offering him as a witness and having a deposition take place in the discovery process, there is a very low likelihood that the judge would allow for him to be presented as a witness at trial, and Wayfarer would and should object. For what it's worth, we don't actually know if he was deposed in connection to his role as the CEO or owner or whatever of Van Zandt, which is an issue that has come up in the concurrent Jones v. Abel case. Anyway, all these other people that have been deposed presumably are on the list by Lively that she feels could support her claims. And so they were deposed, and they may or may not bring these people to trial. They may or may not allow them to testify at trial to support her claims, but they were among the list of people that either Lively listed as being able to support her claims or Wayfarer listed to be able to support their defense. Anyway, for what it's worth, I think if Lively had listed Ryan Reynolds as a potential witness to support her claims, Wayfarer would have jumped all over doing that deposition. Because inevitably, the questions they would have asked would have challenged the marital privilege, and any opening that is created by the testimony that he would have given could have opened the door to a lot of questions that would no longer be covered by marital privilege. If there are more questions about this, please put them in the comments and I'll try and address them one by one, but those are my high-level thoughts on this.